Moving on to another special guest joining us, that's Supreme Court Advocate Sai Deepak. Let's go across to Sai Deepak. Thanks a lot for your time. So, important judgment. Would it be fair to say, to condense it, that the Supreme Court has said that while there may have been some special provisions for Jammu and Kashmir, which in itself are transitory and temporary, a special status does not mean sovereignty. Would you agree that that's really the essence of the judgment? Because in popular narrative, it was being suggested that the Union of India cannot do what it did because Jammu and Kashmir is somehow separate.
So I think this judgment has clarified 2 or 3 aspects. First, that the instrument of accession in itself bestows upon Bharat sovereignty over any province or princely state that has become a part of Bharat through that particular instrument. So that has been clarified. And second, the fact that the Constitution of India continues to supersede any other local constitution that may have been in existence or that may have come into existence subsequently is clearly captured. And which is why the provisions of the Indian Constitution as well as provisions of Kashmiri Constitution have been read together to come to the very clear conclusion that there is no element of residual sovereignty that's been retained by the state before or after the coming into force of the Kashmir Constitution. Okay, so that much is absolutely clear. Second, the fact that Kashmir has been included as part of India's list of states, okay, and the opening provisions of the Kashmiri Constitution itself clearly state that they are a part of Bharat and India, so to speak. I think these aspects have been gone into, coupled with statements or declarations made by the representatives of the state after the accession, such as the statement of Viraj Karan Singh at that point has been recorded very clearly. So I think it's a crystal clear statement, and I'll tell you why this is also crucial. We've been hearing a lot of unlettered comments in the last few months about how India is a union of states, so on and so forth, and these kind of issues have been raised. The reason why this becomes crucial is a state under India, or let's say under the Indian framework or the federal framework, is nothing but an administrative region, okay, which operates under the center, which is very different from the Federation of United States, where different states have come together to form a union.
Right.
That's not the case with us, okay? And if you look at how we divide our powers, so to speak, between the state list, the central list, and the concurrent list, the kind of powers that the union list has over legislations which even the state has prerogative over, or for that matter, with respect to the concurrent list, we have doctrines such as the doctrine of colorable legislation, where if the union happens to pass a legislation on a subject which is covered by the concurrent list, and the state also passes a legislation, the union legislation, so to speak, shall prevail under this particular doctrine. All of this only go on to reinforce how we have treated this as an inseparable, indivisible union, and therefore there is no element of secessionism or separatism or residual sovereignty that any state retains upon becoming a part of the union. So I think this judgment has a second order effect as well in light of the controversy that we hear these days.
Yes, absolutely. Glad you mentioned that. But speaking of the impact of this judgment, one question that many are asking is, what about other states that also have special provisions? What happens to those special provisions? What impact do you think this judgment can have, or if at all?
See, the point is, one is a question of the severability of the relationship. And the second aspect is extra treatment that a particular state may deserve because of its historical consequences or its historical legacy. Okay. So I don't think this judgment has the impact of taking away any additional provisions that Bharat may have carved out in favor of Kashmir without undermining its own irrefutable claim of sovereignty over that territory.
Right.
Okay. So this judgment or any observations made in the context of 370 don't have an impact with respect to the Northeast. They don't have an impact with respect to the 6th schedule, so to speak. At least not to the extent of undermining any special provisions. But this much is clear, no provision relating to any state can be used to make the claim that there is a residual sovereignty, whether you call it under a temporary provision or a special provision or a transient provision, because the instrument of accession shall prevail across the board. And having taken the decision to become part of the Indian Union through the instrument of accession, you don't get to revoke or reverse that
Yeah.
particular consequence. To that extent, I think it will have a bearing.
Being an integral part of India is not conditional. That much has been settled by this judgment. But Sai Deepak, I want your opinion on the other thing that not many saw coming. Justice Kaul's judgment, mentions that there should be a Truth and Reconciliation Commission set up. He talks about intergenerational trauma that Kashmiri Pandits have suffered and how this needs to be addressed. But interestingly, he also goes on to say that this commission should not become a criminal court. That this is only about executing a dialogue and bringing the truth forward, not really about punishment. How do you look at that?
I'm happy that this court has finally taken a position on the need for truth and reconciliation, which could perhaps be the way forward for several legacy issues that Bharat faces as a consequence of its traumatic history. However, I'm certainly not. I'm not on the same page on why there should be no criminal action. See, the thing is, the anti-Sikh riots cases still go on at least since 1984. Whether or not they have reached any kind of meaningful fruition is a different question. But the state has not deemed it fit to drop those cases on the ground ki 20 saal ho gaye ya 25 saal ho gaye.
Right.
Okay. The forced exodus of Kashmiri Pandits or their cultural genocide is an incident that happens after 1984, right? In 89 and 90. So it is of recent currency compared to the anti-Sikh riots. So to say that there is no need for or there should be no criminal prosecution, which means that there is some kind of a de facto limitation on criminal prosecution that the Supreme Court is reading into the genocide that has been meted out to a particular community. Okay, the fact is, if limitation as a concept does not apply in the context of individual cases, why should it apply in the context of collective cases? It should apply. It should not apply even more.
Yeah.
Otherwise, where is the deterrent? And for the Supreme Court to say that let there be no criminal action initiated on these, let's say, in relation to this persecution, could have some kind of an unnecessary chilling effect on any step that the government may want to take at some point. See, already the Supreme Court has dismissed 2 petitions in the past asking for reopening of criminal cases. So I think it's almost like a final nail in the coffin.
Yes, there's a lot of consternation amongst Kashmiri Pandits that their plea to look into these cases has been rejected a couple of times. But I do want to clarify one thing, Sai Deepak, that there are some cases, individual cases, that are being reopened. Do you feel this observation made by Justice Kaul asking the government of India to do this in a time-bound manner, that is no bar that an individual cases cannot be opened up? It really wouldn't shut the door on that.
No, I don't think it shuts the door on individual cases, but you have to realize that when Gujarat happened in 2002, then there were tribunals being set up not just to pursue individual cases, but to look at the issue as a whole. Okay. So on the one hand, when you recognize the need for a Truth and Reconciliation Commission, which clearly recognizes that it is a group-related incident, okay, and on the other hand, you say let there be no criminal prosecution that comes as a consequence of this Truth and Reconciliation Commission, frankly speaking, defeats the very purpose. So what does it mean? It means only a token acknowledgement कि आपके साथ ये नाइंसाफी हुई. That's right. That statement can be issued even without a Truth and Reconciliation Commission being established. Somewhere, someone has to be held accountable. And we are not talking of random statements being made, but actual acts of mass murder, sexual abuse, and forced exodus. If the Indian state continues to be soft on this, frankly speaking, that template is being repeated across the board in several other states. What kind of a message are you sending? That there will be no consequences whatsoever, right?
Yes.
So while I certainly welcome the suggestion for Truth and Reconciliation Commission, I don't think there should have been a comment on the need for or otherwise of any kind of criminal prosecution on a group basis. That could have been avoided.
Yeah, but can I just ask for clarity for our viewers? It still depends on the government though, isn't it? If they do take this forward, what manner they take this forward means is up to them. They don't really have to bind it in any manner.
So it certainly depends on the government. It just so happens that to be fair to the court as well, it's not as if the government itself has shown any kind of initiative to reopen such cases on a group basis. It may have done so selectively on a case-to-case basis where it believes that there is some kind of credible material or there is some kind of recent material, so on and so forth. But there was no bar on the government till date and still there was no initiative. With this line being added in the Supreme Court's judgment, at all there was any residual initiative left in the government, I think even that has been taken up.
Yeah, but I still will press. It doesn't mean that when the government sets up a commission, it has to go by what Justice Kaul said and that there will be no criminal consequences. They can still set up a commission and say that no, punishments will be doled out.
Correct. There is no bar there legally speaking. This judgment does not have the effect of taking away the power of the government to have criminal consequences emanating from any such commission that it constitutes.
Okay, I just wanted to clarify that. So it has come as a mixed bag, really. Justice Kaul's recommendations for this Truth and Reconciliation Commission. Sai Deepak, Advocate, Supreme Court, thanks a lot for joining us with your views on the larger issue as well, which is, of course, the historic decision of upholding the abrogation of Article 370.